Then item do not find any information. Sorry, we can't do anything. Dismissed. Yes.
Item number 2.
I just forgot. Yes, give me a.
About the same.
Just wait, let us go. Yes.
This is Tahsildar yesterday has given. Please.
The demarcation schedule. The demarcation schedule on 31st December.
It is the channel, is the flag.
What has happened to demarcation?
It's scheduled on 31st January.
Now, where is that?
The order was issued yesterday.
26, there is a letter.
No, 24/12/2025.
Oh,
This is
that-
the old one.
Old.
IBC number, that is.
Or tender, which is the subject matter of challenge here. Have you cancelled? No.
No,
It is not.
it's not.
In my case, Lordship, only two documents is suffice, Lordship. Lordship, can you come to page? That is.
I think drawing our attention to the clause will suffice.
15.
Word more.
But in my case, Lordship, I was lucky enough for only some days due to fault of the authorities. Immediately I have revoked. That's why this clause I could not.
If clause will go, then
If the clause goes, then what remain?
That's it. We have not participated. They will come up first.
Oh, the clause has to go. In that event, the tender has to go.
Yes, that's full.
One has already been withdrawn.
Yes.
So the rest matter.
that has not been listed out. That has been withdrawn, that has not been listed.
Already passed. How many writ petitions are here?
3.
Now, 3 read petitions.
All are challenging that clause.
My lord, no, my lord. In my read petition 14048, different tender. And my clause is the 13 number of clause in the first tender and the second tender. The 13 number clause was omitted to get upper hand to the private party number.
So we are segregating the third. Write the judgment on 36703 and 11138. These are all the matters concerning this.
He is also that first read petition. Also, that is the containing it 3. There's 3 now. That is one is sanitization, another for parking to do both.
No, the tender may be for the different work,
Yes,
but containing a particular clause.
yes.
I am asking this,
Must only
that
one.
they are challenging the clause is common
Yes.
in both the tender. So we have to decide that clause.
Yes, now
That's all.
that's one. And another, there is a third one, the third read petition, which
In
are
which
separate that is
Mr.
challenged.
Gunakar,
Yes,
please identify those writ petitions where this clause is challenged. What are the writ
one
petitions?
petition now? Your lordship only one read petition.
Which
That
one?
is challenged, that is
Which one?
138.
1138.
And third one
Let us finish.
is GIS.
Then.
Clause 15 has been challenged. Tender annex of 2. Page 42, clause 15. Eligibility criteria.
Then why all these matters are tagged together?
Yes, I one PL. First track.
I'm looking at the first.
First one is
The
PL.
first-
Lordship. Because of this PL.
36703.
PL has been filed because the sanitization sweeping has not been done properly in
number
the
15 was
Balesur
listed.
town.
Just a minute, just a minute.
No. I have seen, no, I'm just looking at the scope of those writ petitions. So this is the public interest litigation.
And parking fees, my lord.
In providing of occupancy in daily market,
Sir, I
It
mean,
is a third
I'm a
one.
different here. The order dated.
My lord.
In first matter is
24.
yours.
23 format order. This order. This is in relation to 10917.
So why he has placed this? there, this
No, no,
clause.
this
This
was.
is the order passed by this honorable court. Due to pendency of this case, the sanitation and other sweeping works are not carried out.
Sir, now they floated a tender for this purposes.
My lord,
They floated a tender.
my lord, now due to this.
Now the conditions imposed in that tender is now a subject matter of challenge.
My lord,
So if that goes, then your PIL should also go because they have already done it. They have to float a tender afresh
my,
and they have to ensure that everything is done within a time frame.
yes.
Nothing more can be done in your case.
No, my lord.
And what about 10917, which is withdrawn earlier?
Earlier, my lord, 10, that is, yesterday.
Because Annexure 2 series, I find the orders are annexed.
Both of the cases, Annexure 2. It's part of which is withdrawn, Annexure 2. And now.
So now what was withdrawn?
Yes.
I am in dilemma, sir. You peoples, please give a clarity.
You are appearing in all the cases.
Yes,
I should have prepared a chart.
Each for municipality.
This is appearing in all
So he is
cases.
a common council and all.
10917 2025, which is withdrawn.
Yesterday.
Yes, sir.
So this order also goes.
Yes.
23-4.
Yes.
That is what I really wanted.
Yes.
And 11138 is the challenge. And he says that 14048 is a different one.
Same tender, my lord, the clause we are challenging again.
So if the entire tender goes, then what remains?
Flush.
Then what remains? Tell me.
The first.
Sir, I am asking you a very question. If the tender itself goes in any of the writ petition, then what remains in your writ petition?
May I clarify in that with respect of 4, here is the limited point is also, like third one. There was the one, earlier there was one tender, which was cancelled, another tender was that one was not cancelled, they have compressed release. That is the only point.
There can't be.
Yes.
Once the second tender is floated,
Yes.
it implies that the earlier tender has already been
Yes,
cancelled.
that is,
There's a two settled proposition of law, nobody can dispute on that.
that is the only thing.
1138.
We can take
1138
up,
is.
we can take up all together. All the three writ petitions are taken up together.
or 4.
Yes.
My think about it. Lordship, regarding online submission of PMD, but here is the submitted valid value. Your Lordship delivered a judgment. But it is a
Little bit different.
clause difference. The calculator and the
When you have come, then definitely some distinguishing feature will come.
Here is the case, your Lordship judgment that the clause 34 to interpreted that will be required submit after selections. So this is the clause. The Lordships, this judgment, Mr. and which is by delivered by your Lordships. That paragraph 8.2 is the 8.1. This clause is interpreted that post selection I have disease accepted. But our case, in the instant case, there is a COVID circular, and even if it is a COVID period, but it was currently incorporated in the tender condition for acceptance, and the basing on that, other authority also accepted.
So we have held that this clause 34 is to be applied after the acceptance of a bid,
Exactly.
not before.
Exactly.
So
So, instant case, your Lordships, the present case, your Lordships, there is a tender notice under 2016 law. There is admittedly there is a condition for online bidding conditions. Apart from that, we referred a COVID circular, which is integral part of the tender notice. This said circular in the year of 2021. They say that this the circular which is borrowed from the OGFR rules 2017, and this bank guarantee is acceptable. Circular, even the circular was COVID-19 period 2000. It was incorporated consciously in the present tender notice, and similar situation I have stated paragraph 12. Others has been accepted tender. Others EMD by who are valid EMD submitted bank guarantee, they are accepted. And I am submitting the today deed. I have stated paragraph 12.
So
I am submitting the
is a clear case of a discrimination.
Page number 15, my lords, annexure 1, which is under challenge. Here, one petitioner and serial number 21 was disqualified on the same ground, online EMD not submitted.
But he says that in respect of the others whom you have qualified, without indicating anything, they have done the same mischief. What is your reaction to it?
This I was not aware because from the.
You will not. Your authority will never say.
paragraph 12.
Obviously, you will not be aware. That's a very, very serious question he has raised. You have disqualified him on this ground, whereas you have qualified the other bidders on the same ground.
Same department.
How that can be done?
I have stated in my read petition paragraph 12 and supporting document.
So when is the last date of?
They have already opened Miller or technical bid. As per my information, at the time of filing, price bid was not open because there is a 14.99 locked in Miller. I also Miller quoted 14.99.
If I may take 1 day's time for getting instruction because the
That I expected. I was going to dictate it naturally because
I
of the usual phenomenon. Obviously, we have to give a time.
the technical bid was rejected in the month of December, my lords, and the reputation was filed 1 month after that, my lord. Only 1 day's time whether this information is correct, my lord. That's it, my lord. Because from the record it shows that one more person was disqualified on the same ground, my lord.
Obviously, and if more have been qualified, ignoring that point ground. What?
Well, if this is true, then.
And here there's specifically a word in paragraph 12.
Now, Lord, I was supporting documents given nearest same department. I have annexed the BG, my BG as well the technical bid result. You also the technical bid document after collecting the documents. You also
Here the tender conditions specifically mentions that it has to be done through online method. And entire process is also described step by step.
So if others have done who have been qualified in the same fashion in the physical form, then
then you have to check whether there's a power of relaxation. If power of relaxation is there, then it is
Then
applicable.
can you
to-
exercise in a pick and choose manner?
No, Malad, that cannot be done.
So
To that effect, Malad, I'll take instruction whether this.
the uniformity is the hallmark. Tomorrow? Oh, good. What is your homework? Tomorrow, keep this matter on the prayer of the additional garment. Is
Item number 5.
Name change. My election was
yes, sir.
my election to the office of was questioned on 2 grounds. That is, I am unable to read and write Oriya. And secondly,
You are unable to read, write.
write Oriya in terms of section 11 to B of the B Roman 2 of
So
the.
can you read and write?
But that I have shown. But here I have raised a point for your lordship's consideration. And the other point was I had some deferred in some cooperative banks which has not been accepted by the court below, and that is no more the question for my disqualification. The learned trial court, your lordship will see the judgment at Annex 55. In fact, I have raised a point where
No, the main focus was on this particular point that you are unable to read and write Odia. That's a vernacular language.
But
And the court has found that yes, there is a piece of papers also with the writing of alphabets only. There is nothing which you can comprehend. The proficiency in language is apparently lacking. What more you want?
here my humble submission will be, in fact, the approach of all the forums below is completely erroneous, not in consonance with the provisions of DPR.
True.
And but I bet.
I appreciate.
But why I'm saying.
I appreciate.
Well, why I'm saying that what has been done here is the present appellant if your lordship has been called upon to show that he is able to read and write Oriya instead of the election petitioner being called upon to establish that yes, I am unable to read and write Oriya. This is what I beg to submit. And your lordship, in fact, a bare reading of the land trial court judgment.
That was done that you write it, you could simply write some alphabets, nothing more than that. You cannot form a sentence. You cannot do it anything. If that being the position, and you yourself is admitting that this is one of the essential conditions to hold the post of a sarpanch, that he or she must read and write Odia.
That is the requirement of my.
That's true. That's yourself.
So I'm nothing to dispute about that. What I humbly beg to submit if your lordship will only peruse my lord section 35 of the Orissa Gram Panchayat Act. In fact, the present section of petition commences from section 32, 31. Then 32 is parties to the petition. 33 contents. Content says it shall contain consent statement of material facts on which the petitioner relies. And the election petitioner simply says one line that I am not able to read and write Oriya. He has not made any material.
What material can be
I
produced? Tell me,
so.
sir. You are a senior advocate. You know the nuances of the Evidence Act. Now tell me, if somebody says that you can't read and write Odia, what evidence one can produce?
But that also I was asking myself. I have an answer to it.
Yes, please.
And that
Tell
would
me
be
the answer.
like he producing some office record where I am unable to pilot.
You are holding an office for the first time. What record?
But the records were because I have to sign all the papers in Odia. Then I have to pass the bills and everything that is being done. Those records could have been called for. Here, what I humbly beg to submit.
Have you published any of your the poem or prose or any letter in Odia you have written in your handwriting?
But that I produced. That was marked as Exhibit A. So, but the court said that it's not a question of sufficiency.
What you produce that, it is only the alphabets which you wrote.
And I also produced.
Write a sentence.
I also produced my certificate that I have.
Write a sentence. Is your client here?
He's not, she not here. Now, I have to clarify one thing, the approach. Your lordship knows in a case, here
I did not notice it. Secondly, it is really in the nature of a second appeal.
Not
Because one has gone to a civil judge, then the matter has come to the single bench by way of an appeal. Now it is really like a second appeal.
not
The limited scope is that we can't reopen the entire issue. We can't hover around the nuances of the evidence only on a limited ground of a perversity, on the limited ground of a wrong application of law, on a limited ground of violation of any of the provisions of law.
absolutely grateful, your lordship.
We will not enter into evidence. We will not. Both the courts of fact have already taken into account.
I will not also request my lord, your lordships to enter into the facts and appreciate and reappreciate whether the findings are right or wrong. I am trying to demonstrate from record that there has been a fundamentally erroneous approach to the case, resulting in declaration of my election as void. What is that fundamentally erroneous approach is, if your lordship sees the procedures with regard to trial of an election case as provided for in the Gram Panchayat Act, and if your lordship sees section 33, it speaks of that, my lord, like unlike in a election case of MP and MLA, here also it says that it shall contain concise statement of material facts on which the petitioner relies. Then section 35 provides with regard to the procedure to be adopted by the election tribunal. Subsection 6 says provisions of Indian Evidence Act is applicable. Now, what I humbly beg to
Those have been marked exhibit.
what I humbly beg to
You did not raise. Then the question is that suppose if the document is tendered by a witness, and those have been received in evidence and marked exhibit, can you later on say that it has been improperly received in evidence? It has been wrongly marked as an exhibit at this stage or at the appellate stage or at a later stage of the same proceedings.
Here, what I humbly beg to submit, the initial
2002 Supreme Court judgment I am just citing of Justice S.B.
in fact, I have one judgment in a different context where one order for recounting was done by the Honorable High Court. Matter was carried to the Honorable Appellate Court. One of the pleas that were taken for the Honorable Appellate Court is that after recounting, the result has become otherwise. Honorable Appellate Court held that since the very ground for recounting was non-existent, even assuming
So
after
this is what I
recounting.
am saying. That is a different story. Something which has not been made. The civil judge, when he decides the petition and then invited the parties to adduce evidence, the parties have adduced the documentary evidence, and those have been marked as an exhibit. Then in that event, should be taken into consideration. You can't say that those cannot be taken into account. You should have raised an objection. Any evidence dehors the pleading. That should not.
Madam, what I
But
humbly
you did not raise an
the
objection.
proposition of law which I raised before the Honorable Single Judge, namely that in view of the fact that the provisions of Evidence Act is applicable, obviously 101 applies, and the initial burden will be definitely on the election petitioner.
Person.
And if the lordship sees the exhibit on behalf of the election petitioner,
Once the initial burden or onus is discharged, then it should be upon you. It's a reverse one. So once he produced certain document, then his initial onus is discharged.
he has not produced
Then
anything.
what
That
are
is
you
what I
talking?
get to submit.
These exhibits say and everything
Your
is
Lordship,
there.
kindly
It
see
says that you can't write.
Page 41 of the trial
You
court
can't
judgment.
write.
The documents have been marked. the documents exhibit
No,
that
no.
has been marked on behalf of the election petitioner. Nothing of the document shows light with regard to my ability to read and write
It's a
Korea.
piece of it. It's contained there. The very, very alarming fact is, in the cross-examination, you yourself has admitted that I am unable to write a sentence.
But one thing I have to point out,
Mahatma Gandhi, Roजगार Yojana, you cannot write.
but in fact,
So you will be holding an office of a.
I have raised a point if your lordship tells that you-
Never is the point, sir. In the cross-examination, then what more? What is the nuance? When you talk about the Evidence Act, then this is the part of in a cross-examination. Even a leading questions can be put to the witness. There is no difficulty.
I have no quarrel over that.
There is no quarrel over the proposition. If the cross-examination shows certain admission, which strikes at the root of the entire issue, what more?
My if your
What
lordship
more?
if your lordship sees issue number 6 at page
He
33,
will not.
he has anything except that I should disprove his case, but he has not produced anything, zero material. That is what I'm
Anyhow,
getting.
sometimes the admission is taken as
But
sacrosanct in
in
the
fact,
evidence under the Evidence Act.
And in fact, if your lordship's
I
proposition
am
that-
asking you,
Yeah.
admission of a witness, either in the examination in chief, or in the cross-examination, or in the re-examination. What? Does it require that the material to be proved?
in case where
What
the
more?
election case has not
Sir,
been tried as
no.
election case at all.
No.
That is what I beg to submit.
Anyhow, both the courts have concurrently found.
True it is, madam. I am suffering a concurrent finding.
Anyhow.
But if the total approach is erroneous, certainly your lordship can interfere.
No.
This is
Good
what I
point.
can point out. Nothing beyond this, my lord, because
Everything.
if the lordship only sees that-
Their admission in the cross-examination.
issue number 6 only your lordship will have a chance
No.
at page 33. He starts with me. He doesn't speak about the election petition or whether he has done anything or not. That is the whole difficulty, my. Your lordship only see page 11 of my appeal memo, and I have indicated the findings are forward.
Where is the memo?
This appeal memo, my lord, page 7, paragraph 11.
Then how the appeal memo contains the statement of facts?
No, my lord, this is the point I asked for the honorable single judge.
I'm asking you, you are a senior advocate now.
My-
When you talk about a civil law, then I'm going purely on a civil law.
My
Under Order 41 Rule 1, it should be under the, in the form of a memorandum.
I
Does it
understand that.
contain any statement on
Absolutely. Your
affidavit?
lordship raised
Any
point.
memorandum of appeal requires any verification or
Absolutely
or
not.
a.
It has not been done well.
So
It
why it is
started
not done?
being agreed. I am conscious of those old school of law, when we started also in 90s, that it is only starts with being agreed, not the facts. But I have just indicated for the sake of convenience what are the point I have raised.
In the form of.
I could have given us in a separate memo. I apologize for that.
What memo? His application has to be there.
Separate file convenience sheet also I could have given it.
No,
But your lordship.
but anyhow, we don't think so on the basis of the fact.
The only thing that I tried to, your lordship said whether it's a perverse, I have tried to demonstrate a perversity. That much I can.
We have noticed the admission in of your client is what more?
I feel I have assisted enough, my lord, and that is it.
That's the admission, clear admission on your.
I cannot
Nothing.
go beyond this, man. And this point your lordship raised whether the appeal memo should contain all these facts or not. Recently, I think 15 days or a month back. I know that. I am conscious of that, man. Your lordship is very much conscious of this position. I am conscious of that also. I have nothing more to say because
There have been
My lord, after
my
appointment number 1, Lord.
respondent.
You have initiated the proceeding.
No, my lord.
Yes? Who are you?
I'm on the appointment number 1, my lord.
the election petitioner, he's saying no.
That is what you initiated the proceeding. I said so. He says no. He said no. I do not know.
But the appointment one initiated that proceeding.
No.
So, in the own admission, my lord, the appointment number 3, this petitioner admitted that.
Don't go by what has been observed by me or by the bench. What's your case? It is only in pursuit of understanding the fact and the proposition of law. It cannot be treated as sacrosanct. What is your case? He has taken a plea of Section 101 of the Evidence Act. The initial onus to prove the fact lies on. Have you been able to prove any document?
My lord, during the cross of examination, my lord.
Have
the
you
petitioner-
produced? He says that in an election petition,
admitted
not
that.
only you have to plead, but you have to also prove by a cogent evidence. What is an evidence you produced in support of your contention?
My lord, he is not, the petitioner is not unable to admit the, unable to read the write at the Oriya during the cross of the examination. He
Right.
admitted that.
So the court will fish out an evidence for you. Is it not your primary duty to prove it by any cogent evidence? Tell me.
Unlike, in the cross examination, the petitioner.
What is the utility of the onus or a burden of proof under the Evidence Act?
Once he admitted that he is not, he is unable to read and Oriya.
Was given an opportunity to explain such admission by way of a re-examination? Not given. The Evidence Act prescribes for three stages of the evidence. One is the examination in chief, another is a cross-examination, third is a re-examination. Why the re-examination was not ensured?
During the cross examination, the petitioner admitted that he is unable to read and explain.
But he has a right to explain.
My lord. And she admitted fact that he is not able to write the sentence such as Mahatma Gandhi Gramina Rojgar Yojana, RAMAN Panchayat. It does not mean that the petitioner narrated that, my lord.
Now, possibly he should have remained silent, only said I am appearing, and that invited the trouble.
Yes.
Item here.
6
6 and 7 both are withdrawn.
withdrawn.
Item number 8 is
Removal.
My lord, I would like to submit something, my lord. My lord, because my lord, after my 35 years
In this matter, we are filing counter affidavit today, my lord, because there was a bereavement in the family of the superintending engineer. I am serving a copy to my lord junior. Some factual aspect.
File a rejoinder.
Yes,
How much?
10 days time.
Fortnight.
Yes.
Are you filing the hard copy?
Yeah, I'm filing e-filing.
That he has already filed the counter affidavit. And a copy thereof has been served upon the Yes.
Item number 2.
Mr. Palak, I understand that Mr. Palak has been engaged in a matter. What should the matter on behalf of Mr. Palak? What should the matter cooperates to tender matter where we are challenging the
Madam, you are ready with the matter. So you, yes, you make the argument.
may I? Not sure I can face the facts. Not sure.
Yes.
I can pay for a password. One possibility. Not sure we are challenging the blacklisting order at annexure 7.
Little louder.
We're not sure we
I always insist to raise your.
We're not sure we are challenging the blacklisting order at annexure 7 of the writ application, page 71. We're not sure the main issue here in the writ petition is I have the petitioner has been blacklisted without prior show cause notice of blacklisting. Not sure.
No show cause notice was issued.
You're not sure. No, you're not sure.
Where you have stated?
To para,
Where you have stated?
you're not sure well cited the judgment.
Madam, there should be some foundation where you have stated. In your petition, you must have stated that. Where?
You're relying on judgment work as a theory.
First thing is that you should marshal the fact. When the court is asking a question on fact, then you should show you have raised a very important point that the order of blacklisting is slapped on you without issuance of the show cause notice. You must have pleaded somewhere in your petition. Show me that paragraph. You are taking us to the order. I understand. We know the nitty-gritty of this law to some extent, but first thing is the fact, then the law.
Ancient grounds be a lot.
Is it sufficient, madam, that you take a plea in the ground without a statement on oath? Have you read the brief? Have you not read the pleading? Show us.
think it's, Your Lordship, it's taken in the ground, Your Lordship.
Why is it blacklist?
Your Lordship, the tender was floated. Thereafter, we submitted our price bid, and the price bid was reduced. Our price bid was 127 at page 67. We had quoted rupees 127. Your Lordship, the tender was for catering, providing catering service to the hostels of World Skill Organization, Government of Orissa undertaking. Your Lordship, our price bid was we quoted rupees 127. However, the opposite party reduced our price bid to 120, Your Lordship, without
Which is a ground? Which ground?
Lordship ground.
Can you show me? I have just hurriedly go through it. Just show me. I might have missed that particular relevant portion.
Para 6. Para 5, you have stated that you have quoted 127.
Yes, Your Lordship.
Para 6, you are saying that the LOI which was issued to you, that reflected 120.
120.
Unilaterally, that was reduced. So then why blacklisting? You could not apply. You could not execute this.
Your Lordship, we had inspected the premises. We had inspected the premises.
Where is the ground? You have taken that ground where you have stated. There must be an averment that the so-called the order of blacklisting is bad, having not initiated through a show-cause notice.
Lordship, down A.
A, yes.
Lordship, it's
That is the very omnibus ground of arbitrary, unsustainable. Where is a specific averment with regard to non-issuance of the show-cause notice? Yes. This is the factual aspect. This is no law is involved.
You relate this to MSME guidelines. What is that guide? You are relating this blacklisting to some MSME guideline. The petitioner is within the ambit of MSME.
Your Lordship.
Hmm.
We are a register
But
of the Udyam.
There is some facility or privilege enjoyed by this MSME.
Lordship, and the order, second point, we have been debarred as Udyam portal. That's why the guidelines have been referred to. First, we have been blacklisted with the world's, all the procurement processes of the World Skill Center for a period of 2 years. The second punishment is that we are debarred in the Udyam portal.
Yes, the portal is blocked for you not to participate. That were consequential steps to be taken.
Lordship, down.
Yes. Where is your senior?
Mr. Palin, please.
Engaged in this plea.
You have missed the brief.
No, I have been engaged. He is engaged me.
No, I understand, but
No, we were trying to help locate it here on this.
so only one brief is allotted.
No, she engaged me with the single brief, sir.
So junior does not have, nor he has.
He was actually, he just come from the cricket ground. He was playing for the winning team today. Probably.
No, we actually should not take Mr. Tripathi. You are appealing, I think.
No,
The last
this is,
session. On the last occasion, 45.
2 to 6 minutes.
2 to 6 problem is where it's.
2 to 4.
Yes.
So once it's represented to its chief executive officer, Annex 7 is issued by them.
That will say.
Noting is that neither getting nor onshore notice is by.
And actually issued notice.
Neither ready nor answer notice returned from 2 to 4. So they are answerable.
What happened was.
Well, I understand that you quoted a particular price, you were declared as L1. They unilaterally varied the amount. Then you say, I am not agreeable to give it. There was a refusal. The refusal is taken by them as a default on your part.
And the practice.
And you have.
Without a show.
But you have not made out a case of such engagement.
I'm sorry, Anna.
You have not made out that there was no show cause notice which has been given, except one sentence which I can get it.
It's there in the ground.
Nothing.
Ground C.
Ground C you come is affording an opportunity of hearing, you have said.
Yes, ma'am. That's.
His only ground is not affording an opportunity of hearing. I was inviting your attention to that.
Ma'am.
But you have not said in a specific term that no show cause was issued.
It's not very happily worded.
No, sir. Happily worded.
But he has referred to the right judgment.
Is a blunder omission.
He's referred to the right judgment.
No, erosion, you are taking care of the erosion judgment.
Erosion and all.
I understand that.
Referred to in Gorkha. So.
Whatever, Grosson is also one of them. But you'll have to plead.
Madam,
You can't elaborate that not affording an opportunity of hearing means that there was no show cause, there was no opportunity to give reply, there was nothing. You can't impute.
Let me take your lordship, walk your lordship through the language, Manoj.
Please.
Even though such a grave decision of blacklisting and initiating correspondence with MSME Department for cancellation of Udyam registration was taken against the petitioner, but no opportunity of hearing was ever afforded to the petitioner.
Correct.
The lack of opportunity of hearing assumes significance because the impugned order had a potential to financially cripple the petitioner and taint its goodwill forever. The importance of giving opportunity of hearing before debarring or blacklisting an agency from participating in public tenders has been discussed.
So you have taken a law immediately?
Malak, please.
D.
No.
D.
The next
D last.
for that, the impact
D
of
last
the improved letter.
3 to 4 lines.
Malak, the opposite parties have not resorted to the basic principles of natural justice before taking this drastic.
That is what is a very
Exactly.
too broad a principles.
Malak, that is exactly.
It's a too broad, but you have to work out a specific case.
I agree, Malak. Much more.
And how you have now when you are appearing, then I am asking. If she is there, then I would not have asked this question. When you are appearing, how you have verified this paragraph ground?
Verified in this month, I could not get your answer.
In your verification,
Malak.
how you have verified this ground?
Declaration.
Grounds are true to your knowledge and true to the best of your information. Tell me, sir, can the grounds be verified in this fashion? I'm too technical, I know.
That's the format. High Court.
What is this is the format.
No, not this. High Court
Then-
plays out an elaborate format.
So you'll have to say that up to paragraph 1 to 7, which are the statement of facts. You have to say true to your knowledge. And 8 are your submissions. The grounds are always the submissions.
In fact, for a period of time, this court made it, some courts made it mandatory that the affidavit has to come in that format. And
How a deponent knows the nuances of law and the judgment of the erudition true to his knowledge.
Thereafter, must again relapsed into the old system.
No, sir, most has been in this option.
No, he's otherwise very wonderfully competent.
Yes.
Today he's just,
No, he has drafted it, see.
today, that should not condone this.
No, I understand. That's why I say it's too technical a point, but it's still
For the
No,
youngsters to-
it's a.
for the youngsters to understand.
Not too technical, it is something to learn. Everybody should learn that. Is that they are in the High Court rules. Specific format is also given in the High Court rules. Prescribed. And
Who is for the other side? Who is for the other side?
It has come back answered.
Yes, sir. No.
So 4 works in the meantime, small fellow. Hardly 4-5 lakhs worth of job he is executing. How long can if he is listed in this way and all format?
Who is for the other side?
Sir, they have not sum up.
And I am appealing to OP number 1.
One.
Who has blacklisted?
OP number 2.
OP number 2 has
Has,
blacklisted.
whether the notices have been given?
Notice has gone, Malak. Notice has gone.
How many, 1 month has elapsed? What is this?
No, my appearance. Take it.
So, we are not-
Yes. Here, I make it.
1 month is no? 1 month is long.
Read the latest judgment of the Supreme Court in Jitendra's case. For you. For you, Mr. Parth. For this purpose.
Well,
Very latest judgment of the Supreme Court in Jitendra case.
September
2025 volume
September day.
10 SSC
Demoted is-
by Justice Oka.
That will before may come.
Section 16 of the Advocates Act.
on this, on the appearance.
May call for.
You can talk about it. No, September, he pretty much.
So more than 1 month has elapsed. So presumption of due service we can draw under the General Clauses Act.
Poor fellow is, he should be nowhere.
How can it be filed? This cannot be supported. If you have to give them an opportunity, you should issue a show cause notice, should invite a reply, and he appears to me, though we cannot enter into that aspect, but still, for this purposes, if he has quoted a particular price, how can an authority unilaterally reduce that price? Either you award a contract or you say that unless you agree, then he says, I am not agreeable because he has quoted a competitive price. How can he go? He quoted 127. You say, no, you supply at 120. He said, I can't supply at 120. I have quoted 127. I have been declared L1. I must be awarded a contract at 127. And since he refused, so blacklist. Kind of a
This
attitude is this.
Under your control? It's not under your control.
It's a government of Orissa.
Huh? This World Skill Center,
Skill center, government of Orissa. Yeah, under his control.
undertaken, some department must be controlling it.
No, department.
The
What?
young portal, how could
A
this,
government of Orissa company.
the government?
The government of
This
Orissa company.
Udyam portal, how can this center access? Udyam portal is, I think, maintained by the MSME department.
They have also suggested that
That's a party.
communication that.
Perhaps he might not have made him a party. But Udyam portal has blocked. So Udyam portal is managed by MSME department?
They have initiated correspondence to block.
With the instruction.
And all other tenders, they required to fill up that column are given an additional affidavit manner. I've lost 4 words. Everywhere that whether you have been blacklisted or not. So that undertaking has to be given. So that keeps me effectively out of other works. Not only this particular organization, other organizations are also malades. I am a now personal non-writer there. Sir,
Apparently, this cannot stand.
Yes. But so far this blocking of portal is concerned, it's managed by the MSME department.
I understand because of the order, they have to block. If this order goes, they will unblock. They will unblock. When it was sent.
29 September 2005. So you wrote 4 months.
If it is there, then.
Postal tracking report means so whether it was delinquent.
Huh?
Postal tracking record.
That cannot be done. I think they do not have after certain period of time. Now it was sent in September. There are 2 ways of looking at it. We can definitely raise a presumption of due service after a gap of 1 month and proceed to decide the matter, finally disposing of. Or if you can take an instruction,
I will take instruction.
then we can keep this matter on the next week at the top, or not next week, on a Monday at the top. And decide. This is the open case, open and shut case of a violation of the principle of natural justice.
Yes.
But Mr. Palit, you have to be very careful when you draft. Maybe you're junior, but whatever. This is not a casual exercise, sir. A case which is not made out by a litigant, and then the court is deciding on that basis.
Item number 3.
Ms. Ground to take instructions, please. On whose ground? Whose ground?
He is standing on his legs.
Who?
Sukant.
Oh, that is what I wanted. She's not saying. I think he never goes to the field. Pass over.
Item number 4.
He is leading. He is leading, captain.
No, actually, the
Item 4.
Keep it next week. We are not.
For listing these matters.
Item number 5.
Other item number 5.
Item 5, your lordship, on behalf of Mr. Milan.
Hold your breath. On whose behalf?
Mr. Milan Kanande, your lordship.
What has happened to him?
Lordship, we need time to file the rejoinder.
Router has been filed.
Your lordship.
How much time you require?
2 weeks time to file the.
2 weeks time to rejoin the.
They served a withdrawal memo on us.
Oh,
Whether it has been filed or not, we don't know. They have served it on.
Withdrawal memo. There is no nothing.
There's an IA which has been served.
IA for withdrawal of the present. You have filed an IA, madam.
It's there in the court. Maybe she.
It has come, it
Not
has come,
standing
but
on
it
the
is,
way.
office note was
She
not.
Not well.
Liberty to approve this court. Why liberty? Development has approved this.
No, they, I just wanted to draw that they have filed such an IA, but my learned friend, she is not aware. Let it be.
We are allowing your application, madam. Is there?
I'm appearing on behalf of Mr. Nilankan.
He has a petition.
That's the same thing.
Mr. Kamini, he has a petition.
Mr.
Yes, Mr.
Yes, senior, on whose behalf you are appearing?
Your Lordship may pass it over or something, maybe she let her.
He is in some other court.
Yes, Your Lordship.
Mr. Kanungo has been engaged by another counsel. My friend is not aware of.
No, that's what I'm.
Lordship, as per my instruction, I was directed to take time for.
Already filed in the registry. Now it has come up.
Who is the advocate on record?
Now, who is the briefing counsel?
Mr. Milan sir has been.
Milan sir, you may say, who is office?
Bali. Nicholas Bali.
Nicholas Bali.
Give it to some other.
Take instruction.
Keep it tomorrow as a first matter. It's a question of withdrawal. Tomorrow is the first matter. 30 seconds exercise.
He can come up.
Or if he can come up, there is no difficulty. Where is he?
Lordship, let me pass over the matter.
Where is he? Are you aware?
Yes, Your Lordship. In the-
Where?
in some other court, Your Lordship.
So we are just waiting on him. After finishing that matter, come. We are just keeping matter. Next.
Item number 6.
Which I received the counter affidavit on 7/1. I want the time to reply to the counter affidavit.
Rejoin them. Big one. You wanted to appear after 2 weeks.
Yeah.
Next.
Item number 7.
Your file counter. Open up.
Mike. Items.
Yes.
Item 7.
Time is filing to repeat some, inadvertently you have filed the second phase of the prayer mail. The Lordship on 14/11/25 mail directed us to amend the repeat mail. Accordingly, filed the I for amendment mail.
Where is IA?
20486.
Yes, you can't, I think you can't have anything to say. These are the ministerial error. This is an application for amendment. Spend it till next week.
Item number 8.
Please, Your Lordship. Your Lordship, this is a content matter for non-compliance of order dated 1/7/2025.
Where is that order?
Urgent application number.
Where is that order?
At page 11, Your Lordship.
11 or 14?
In this case, there is a direction to have the fresh tender and to clear the dues of the existing outsourcing personnel. Both the things we have done, and tender has been invited, and outsourcing personnel we have made payment, and bank advisor has been go to.
The order, my lord, kindly see page 18. Page 18 of the content.
Yes.
Page 18, paragraph 9.
Yes.
As the manpower requirement cannot be dispensed with and they are to seamlessly perform in an organization like water and sanitation mission, necessity therefore is to observe that till the new set of outside person or such personnel as may be engaged by adopting any other mode at the discretion of the organization / government undertake the job, they may be allowed to continue. They have released the area dues, but they have just discarded the persons which are engaged.
So they can't. They have to,
It's a
because if the fresh tender is floated, the new person has come.
no. It's not been
Then-
finalized.
A tender has been called, but that for the assessment technical bid that is fixed.
Or then we have already said that
It's a sanitation.
they should
have already
continue.
occupied.
So how can you discontinue them?
So far the distance and concern, there is no instruction with me. I today
But you
talked
have
to
to take instructions, sir.
Today I talked to the chief engineer, he is saying that tomorrow he is coming to me. Well, the aspect regarding distance you must intimate me. Let it
Next
come
week, next week on his prayer.
This is seamless service. Seamless service.
Sanitation.
He is called.
Item number 9.
Yes.
My lord, your lordship may just peruse the order dated 10/12/2025.
10/12.
In that case, my lord, in that order, this honorable court has directed the opposite party 2 and 3 HPCL to give vacant possession of the premises in question to the petitioner within 6 weeks, and to file an affidavit to that effect by an authorized officer of the HPCL. My lord, they have filed an affidavit, and in that affidavit, they have paid for June 30th, 2026 to vacate premises up to June 30th. My humble submission is that, my lord, that it is too long. Nowadays, everything is done with machines and technology, so much time is not required.
Sir, they wanted a 6 weeks time from 10/12/2025. Now, I believe that is over already, 6 weeks time.
That's the observation of the Honorable Court, my lord.
What
Lordship,
is that?
Kindly see that order dated 10/12/2025. my lord. Paragraph 2, my lord.
Please,
This is
I'm
also-
looking at paragraph 2 and 3 both.
Look, I'm obliged.
Please,
In the facts and circumstances of the case,
correct.
my lord, the
So
line
paragraph
just before-
2,
just
please
before-
read
yes,
paragraph 2, last line.
my lord.
No,
The purpose of-
rather whole of it.
My lord. Mr. So-and-so appearing for HPCL raised objection with regarding to the maintainability of the writ petition, but in the course of argument, my lord, maintainability question is still.
Please, then in course of an argument, he fairly submits.
Submits that HPCL does not have any legal right to occupy the land beyond 31/3/2030.
Correct.
He, however, submits that a reasonable time may be given for vacating the premises in question.
Sure.
In the facts and circumstances of the case, we are of the opinion that 6 weeks' time would be sufficient to vacate the premise and hand over the same to the petitioner.
Correct.
However, the competent officer of the HPCL should file an affidavit within 10 days and serving a copy on the London Council stating as to when HPCL shall vacate the premises in question put upon such and such.
Correct.
Pursuant to this order, my lord, I filed the affidavit. And the affidavit, my lord, is before your lordship. It is dated 23rd of December 2025.
True.
Wherein I have stated that this is a long continuing petrol pump and I require time because of various procedures I have mentioned in the affidavit, my lord, that I will vacate by 30th of June 2026. And in the meantime, whatever has been fixed by your lordship by a judicial order to be paid as the rent, I will continue to pay that.
So we are directing,
Look.
don't worry, we are directing the calculation of a mean profits
My lordship will kindly
from
bear with-
2013
No, my lordship,
onwards
bear with me, lordship.
and till the June 2026. So whatever is due, they will go on paying, they will pay all the entire. And the present market rate of letting out, which is prevalent there, they will continue to.
Lord, they have filed an affidavit today. I would like to respond.
No
to that
difficulty.
affidavit. They have filed an affidavit today, my lord, which has been served on the briefing council today, my lord. I had requested my learned senior to grant me a reasonable 2 weeks time. I'll respond to this affidavit, and then your lordship may kindly consider.
Can't you come up with
Whether the royalty is payable on the works of the contractor. Will draw Lord's attention on the judgment of the Supreme Court. Then my lords have also framed an issue on 3rd of August 2024. First para itself, madam. The impugned order passed by High Court of so and so is set aside. The matter is remanded to the High Court to determine the issue of leviability of royalty on the parties in this case. Disposed of accordingly, the parties may move the High Court for interim relief. Sorry, Lord, the interesting is the last 3 lines. Lord. We are informed that contract expires to be decided within 3 months. Lord. So, in fact, the period was infested with COVID, so everything derailed. Initial Lord, intention was to be disposed of this issue. Lord, that's only to be decided whether the royalty will come or not.
yes?
Then, my lord, the Lord's order, which was passed on 3rd of August 2024.
2023.
23, madam. Para 4, my lord, more particularly. Contended question of liability of royalty on the parties has to be dedicated by this court. As the matter has been remanded by apex court, it is contended that if royalty cannot be leviable in that case, the petitioner may not be liable to pay the royalty. And if the question of liability of royalty would be decided in favor of the opposite party, then certainly the petitioner is liable to pay, which is subject to condition of the so Mr. Mishra, learned counsel, opposite party corporation contends that
out of 4, 3 matters have been sent to arbitrator.
Lord, in fact, this should not have been referred to the arbitrator. Probably not the liability. The
Leviability is the main issue, whether it can be levied in this scenario or it cannot be levied. That's the, I think, the moot question that has really arisen in the case. Now tell me that what are this is a pure question of law.
Well, it is.
Pure
Something
question.
on the working, the royalty, unlike tax, is a qui pro quo. In tax, certain because even I'm not getting a benefit, I have to pay tax.
True.
In royalty, both the parties, grantor and guarantor, has to have some benefit. So qui pro quo is must in respect of the ultimate. I'll draw Lord's attention for state away their demand, which is on page 111.
Page?
111 in section 6.
Very dangerous number. Nelson number.
Well, lucky for them, Lord. Certainly, unlucky for the petitioner, but respondent would be lucky in Lord that. 111.
Analogous matters, certain writ petitions that is appears from this office note.
Well, in 28, my lord.
That those have been disposed of. What is this? Are they connected or not connected?
Disposed of, the two other matters.
No, there are 1, 2, 3, 4, 5.
Five, two, so I'm concerned about to dispose of.
What,
And,
what were the,
Sir, they have to go to arbitration those matters.
all 5?
Yes, yes.
Okay. Anyhow, it has got nothing to do with this matter.
Oh,
Anyhow, yes,
Lord, in Exercise 6,
yes.
with the reference to 111, with the reference to letter on dated so and so, I am to say that approximately this much cubic meter of earth was extracted and used for construction. Lord, if I am using, Lord, I go down, Lord, I'm liable to pay. But that allegation was there that I'm using, which would, Lord, certainly was
It
clarified.
was used for construction of a ash pond.
Yeah, ash pond, Lord, the digging and the natural corollary is earth will come out. It is not, Lord, that I'm making something in air, Lord. If I'm digging earth, Lord, certainly, Lord, because for pond purpose, earth will come out. So mere coming out of earth is taxable. Unless until they level an allegation that yes, I was using this and exploiting this earth commercially.
What is this ash pond? I do not know. What is the,
The electricity generated by coal, Lord. So the ash is the waste product, Lord, of the
True.
So just to, Lord, avoid this menace, Lord, they construct a pond, wet pond, put water on the ashes so that it may not.
no, it's because it may not, they spread in a locality, contaminating the air or something.
Yes. Yes. So my responsibility was only to construct the ash pond. Dispute is only related to ash pond, because there are other contractors who were constructing the BTG partner, boiler, turbine generation, and other activities, civil work.
Yes.
I'm only related to ash pond. And my unfortunate part with me is that, Lord, I'm digging earth. Question comes to digging earth to construct a pond. Lord, what do I do with the earth? If I'm selling it out in the market, I'm certainly responsible. If I'm using it, Lord, I'm certainly responsible. But if I'm dumping it then and there in the lease area, then, Lord, my humble submission is that this liability is not even in terms of law. Then, Lord, with this, Lord, then I gave them a reply, which my Lord would find on page.
No, under what provision this royalty can be charged? They must have shown. Where is the charging
Section
section
3, Rule 3 and Rule 25.
of
2016
minor mineral concession rules? Rule?
Rule 3 is the definition and Rule 25 is the charging section.
No.
Minor 3 is the definition. So mining per se is not taxable. No royalty is payable on mining. Even if I'm conducting mining activity, I'm not bound to pay.
No, you're referring what provision?
Because 2016, Orissa Minor Mineral Rules.
Concession rules.
Orissa Minor Mineral Rules. Is it concession?
Is the concession rules.
So minor mineral concession rules, 2016.
Rule 3 is
the definition.
The restriction on prospecting or the mining or acquiring operation. I think you are referring Rule 2. That's the definition provision.
But Rule 3.
You are looking at 2016 or what?
Rule 3 is restriction on prospecting.
Yes, that is what.
Rule 3 is the restriction. No person shall undertake any prospecting operation or mining operation or quarrying operation for minor mineral in any area except under in accordance with the terms and conditions of a prospecting license from mining lease or a mining lease or a quarry lease or a quarry permit, as the case may be granted under the, provided that extraction, collection, removal of mineral by a person from his own land for normal agriculture operation or other bona fide domestic consumption shall not be construed as mining or quarrying operation. Provided further that nothing in this rule shall affect any prospecting or mining or quarrying operation undertaken in any area in accordance with the terms and conditions of prospecting license or mining lease and quarry lease or quarry permit before commencing the rules which is in force at such commencement. Provided also that nothing in this rule shall apply to prospecting operation undertaken by any agency or organization of the state or the central government. Then, Lord, I think rest will not be much of relevance. Lord, then would draw Lord's attention on 25, which is the charging section. Lord. The 25, the title even liability for payment of royalty dead rent amount for district mineral fund is so and so. Will draw Lord's attention on sub rule 5, royalty shall be leviable on minor minerals, interesting is removed from the leased area. So it is not extraction which is taxable or payable. Removal from the lease area. If I have a lease area of 5 kilometers or 5 meter, and I take out earth from that lease area, then the charging section will come into being. My submission is that I am not falling in the charging section, and the imposition of the royalty without in divorce of charging section or something which is not permissible.
True, there is no difficulty.
Right.
But exemption under section, under rule 3 is only for agricultural purposes.
At best, I might be conducting a mining activity. At best, I might be falling within the parameters of mining. But the issue is of imposition of royalty. The issue of royalty would come only when I'm doing something, exploiting it commercially or taking it out from the leased area, as per 25. If I'm not taking it out from the leased area, I might be a miner, but not be liable for payment of royalty. This is what is humble submission is. But in that way, this is something this section can cause so many menaces. Say, for example, at my house, somewhere in my factory or industry, somewhere I'm constructing something, a pillar or post or something. I'm digging up. According to them, this is a mining activity. So my submission that yet let it be a mining activity, but whether this mining activity is inviting royalty. To invite royalty, it has to have the compliance of 25. And interesting is the reply. Additional minors have directed them to file additional affidavit just to find out as to what my activities are. So they put sufficient light on that I am only expecting. So my liability and responsibility is only that I am extracting, so I am liable to pay royalty. That is the only allegation they have. Then we are not saying that I am using it or I'm commercially exploiting it. There is no allegation as such. I'll just read their additional affidavit filed in 2024.
Yes.
We'll draw Lord's attention now on the additional affidavit, which was filed on 18th of July 2024. The date is 18th of July 2024 by respondent number 3 and 4, the main respondent. Draw Lord's attention on paragraph 12 onwards now.
Are they invoking serial number 33 of the second schedule of these rules? Ordinary earth?
I think it falls within the definition of ordinary earth.
Yes. Is an ordinary earth.
My lord.
So it is at 35 rupees per cubic meter.
Yes, that is the royalty payable.
Yes.
Lord, I will request my lord to kindly consider their counter affidavit as to what is the maximum allegation level against me, what type of work I am executing. Lord, the additional affidavit was filed by them pursuant to Lord's direction of 3rd August 2023 on 18th of July 2024. This was the last document filed in this series.
Yes, what they say?
I read paragraph 12. In paragraph 12, onwards, not 2-3 paragraphs with my lord's permission. Paragraph 12 says that it is an admitted fact that opposite party number 5 is OPGC, being a lessee, was granted for construction of thermal power plant in this case. For said purpose, opposite party number 5 had engaged the petitioner as a contractor for construction of ash pond at Tilia in district Jharsuguda. The petitioner excavated the earth from the land, which was leased out to the petitioner by way of lease acquisition of pond. It may be noted that in the said construction of ash pond, the petitioner excavated the earth from the land by way of engaging different machines, which attracts royalty. So allegation is that I extracted, so I must pay royalty. Charging section says that I must take it out from the leased area. at least I should have used in the leased area. I can say that intendment, but there is no role of intendment in tax law. But I go a step further. I say presume that I used it, but it must be, might have used in the lease area. This is no allegation as such. I expected to pay. Then Milord, para 13 also. 14 Milord, rather. 13. 14. 13 is they have quoted the provisional section Milord, as to how it is payable. 14 Milord, that it is further submitted that the petitioner extracted earth from the land for the construction of ash pond of opposite party number 4 for commercial purpose, not for domestic purpose, which is exempted from payment of royalty as stated in Rule 3.1 of Odisha Mandal Act. The removal of earth from the land for construction of ash pond of opposite party is not coming under the bona fide domestic consumption, as the ash pond was constructed for commercial purpose. So actually ash pond was constructed for construction was commercial activity. So my extraction would automatically fall within the definition of commercial activity. It is not that I am selling out the earth, or I am making a road, or doing something for which I could have borrowed earth from the outside by making a payment. Here I am that setting the payment, so I must pay royalty. It is not their allegation as such. And the onus is on them to prove that yes, I am commercially exploiting. Then, my lord, 15 also, that it is further submitted that lease principle under OGLS Act, the surface land has been leased out but not mineral. In view of aforesaid, it is clear that the opposite party number 5 has been provided the land which shall have no right to use minor mineral on it. In case the extraction of minor mineral, then it has to pay royalty. Again, the only extraction. It is repeated in para 15, then para 18, in para 19. Same the allegation.
Yes.
In para 19, Lord, they are coming up with a judgment of Supreme Court. Lord. I'll refer to your lordship. Appeal number of 1996, where the Supreme Court has specifically observed that royalty is payable when the earth is extracted. I agree. That is in respect of 1990 regulation rules. In 1990 rules, my lord, the extraction of earth per se was taxable under royalty, my lord, payable and royalty. Not in 2016. That difference is there. I'll show to your lordship 1990 rules also, the Supreme Court judgment also. And in that case, my lord, the project proponent was utilizing it commercially. In fact, it was a railway, my lord, railway was utilizing that dicty for the construction of railway lines. But that is different issue. The extraction per se under charging section was payable, royalty was payable for extraction in 1990 rules. After 2004, rightly, my lord, because 2020 there was an amendment brought out in mineral concession rules, where they say that either you use run on the river or run of the mines, something terminology had come, that either you use the mineral in the same area. If you are using in the same area, then you are liable to pay royalty, or if you are taking it out.
So that's the concept of a captive mining, where you are using the entire ores for your own consumption, which is there, you have set up there.
So that the amendment had been brought to the Act, my lord, in 2000, and thereafter, my lord, 2000 onwards, my lord, they have started using the word removal from the lease area or use or consumption. In our case, my lord, it is only removal from the lease area, but I take a responsibility if they allege that I am using it. Then I am using it for what purpose? This is a waste product. For digging the construction of pond, I don't need earth. Rather, I have to remove it and throw it out. Instead of throwing it out outside, my lord, I am putting it on the embankments. So what offense I am committing? So far, my lord, the section Rule 3 and Rule 25 are concerned. And I have series of judgments, my lord. And some say that it is not even a mining. Uttarakhand High Court, my lord, Telangana, Mumbai, Hyderabad, they say that even not a mining. So Supreme Court says that if you are using it, then this is payable, otherwise not using it. You cannot stretch this definition to that extent that even simple work and digging will come within the realm of royalty in promoter's case. I'll read that Supreme Court first, then we'll come on my judgment parts with Lord's permission. The Supreme Court was my lord to see 1990 Act, rules were 1990. 1990. You will have a example of. And this is also the rules. Yeah, where is it? 19.
Talking about 1990 or 2004?
1990, because much reliance is on a Supreme Court judgment law rendered in 2000. That was based on 1990 rules. The dispute between state of Odisha and the Union of India, interesting dispute. Because they are charging me only because of that, despite the fact that I do not fall within the charging section.
Central government not a party. Central government not a party.
In that case, it was not in this case.
Yes.
My lord, 1990, my lord, rules are, I'm so sorry, my lord, I'm not having hard copy.
Yes.
My lord,
Just place it.
please, my lord. I'll read with Lord's permission,
Yes.
the charging section of this section, rule 13.
Yes.
Liability for payment of royalty dead rent. The lessee shall be liable to pay dead rent, surface rent, royalty, and fee for compensatory afforestation at the following rates, namely: royalty shall be leviable, Roman 2 million, royalty shall be leviable on manor mineral extracted from the legal. That was the situation in 1990 till 2000. The moment mineral extraction is done, offense is committed, which is not the situation now. Soon after 2004, not the situation has changed.
Which section you are referring?
My rule 13,
Sorry, rule?
1990 rules.
No, which rule?
1990 rules. Odisha minor mineral rules 1990.
Which specific rule?
Rule. 1(3). Liability for payment of royalty. 13, my lord, rule 13 sub clause Roman 2.
Yes.
Royalty shall be leviable on manor mineral extracted from the legal. So the situation post 1990 was mere extraction was taxable, if we call it royalty as a tax. So the imposition would come the moment I'm extracting the mineral. This situation is not after 2000. So the judgment of Supreme Court being referred to and rely upon law is in respect of 1990.
Yes.
Lord, then I will draw Lord's attention on some of the judgments as to how Lord the states are treating it. This activity, Lord. First is Lord, state of Uttarakhand. Jayaprakash Associates versus State of Uttarakhand judgment.
Yes.
Lord, para 7, we'll just read 4 lines. The intention, Lord, para 7 says the contention of learned counsel for the petitioner is that excavation from the foundation for raising building in the land owned by the petitioner does not amount to any mining operation. In the definition of mining operation stated above, it has specifically been provided that the intention should be for the purpose of winning minor minerals. My intention is nothing. My intention is only to construct the hatch. I'm least bothered about this art, which is a waste product for me. Then Lord, my Lord, my Lord, para 11, Rule 3 of 63 provides that the holder of a mining lease granted on or after commencement of these rules shall pay royalty in respect of any mineral removed by him from the leased area at the rates for the time being specified to these rules. It means the royalty is payable only by the holder of a mining lease granted by the government in respect of mineral removed by him from the leased area at the rates as fixed by state government. The petitioner in support of the case also produced the judgment given by Division Bench of Allahabad, so and so Sharma and company. The facts and circumstances of the said case are fully applicable to the facts and circumstances of the case in hand. Paragraph 10 and 11 of the said judgment has been held as under. I'll draw Lord's attention on para 11, which was quoted. Under the rule, it is the holder of the mining lease who has been made liable to pay royalty in respect of the minerals removed from the lease. So wherever it is written, the removal is taxable, then certainly I have to pay tax. Then next is Supreme Court. It is promoter and builders. Straight away, my para 13. It is therefore, my lord, with permission, para 13. It is therefore clear that ordinary earth used for filling or leveling purpose in construction or embankments, roads, railways, building is deemed to be a minor mineral. It is not in dispute that in the present appeals, excavation of ordinary earth had been undertaken by the appellant either for laying foundation of building or for the purpose of widening of the channel to bring adequate quantity of seawater for the purpose of cooling the nuclear plant. The construction of building is in terms of sanctioned development plan under MRTP Act, whereas the excavation widening of the channel to bring seawater is in furtherance of the object of grant of land in favor of the nuclear power corporation. The appellant builder contended that there is no commercial exploitation of the dug up earth in as much as the same is redeployed in the construction activity itself. I too had not redeployed this. In this case, I'm sorry.
Yes.
There are so many, Lord. I'll draw Lord.
So the entire judgment that you are relying on, they are really focusing on the issues that if you excavate the ordinary earth for the purpose of construction of a building or for that purposes, then in that event, it may not tantamount to this.
Right.
Secondly, it must be within a mining leased area. If the lease is not for the mining purposes, then it cannot come under the mining leased areas. So one of the judgments says that you can't levy.
This is, yes.
It's too far
Yes.
that view has gone. So according to you, that mere digging and then using it there itself and not taking it out does
Should
not
not be.
really tantamount to this.
Should not.
And once the sanction is granted for the construction of an ash plant, ash pond, then the pond connotes that there must be a digging that has to take place. If that digging has taken place, then in that event, it does not be considered as a mining activity.
I go down. Yes.
This is, I think,
This is your
the entire
Yes.
sum and substance or summum bonum of your case.
Please. And the only, my lord, the person who can object to is the government, my lord. And the government has, with Lord's permission, I read out the affidavit filed. The allegation is also that of extraction, that you are extracting so pay. Probably under the misconception that
1990 rules uses the word extraction. Is anything more?
That's right. Yes.
Who is for the government?
Sir, government is there.
You are for?
Sir, I am appearing for the OP number 5, who has engaged them to execute the work.
Then you'll have to pay them this royalty.
Right. Actually, we are not claiming royalty. Government.
I understand that if some impositions are there,
Yes.
which is a statutory in nature,
Right.
then you are responsible to reimburse him.
Deducting it. That is
So
exactly.
definitely you will be siding him or will be standing by his side, or one is an alter ego of another.
So once I accept that yes, royalty is payable and I have paid the royalty.
Then you are in soup.
So I have to get it from him.
No. You have to reimburse.
Because once it has been deducted, kindly see, government has taken the money from me. I have paid the money to government.
Royalty?
Yes.
Oh.
I have paid the royalty to government.
Deducted from me.
So I have to deduct it from
So really you acted
Right.
detrimental to his interest.
No, detrimental to both interests, but not his interest. It's also
No, your action is detrimental to his interest.
government action is detrimental to my interest. So that is how it is percolates to him. And here, one thing you should kindly see. There is a decision.
I think you will also be supporting that it is there no royalty can be imposed so that you get your money back.
Then the question of law. I am in the question of law, madam. I am not on the whether to support him or to oppose him. If you also kindly see, there is a Supreme Court judgment relating to a railway track or the extraction of earth from while digging a railway
That
track.
is what he was referring, that was in relation to 1990 rules. There, the word, I think rule 13 he's quoting, the word which is used is extraction of the ordinary earth.
Right.
So the word extraction means any action or an attempt to take out the ordinary earth from its natural position. I think in a way more truncated manner, this may bring the concept of an extraction. But again, for agricultural purpose, for the purpose of plowing, for the purpose of
Domestic purpose, agricultural purpose, or for his own land, is not applicable. The section rule 3, if you look at 3, proviso. 3.1 proviso.
that is in 2016.
Yes.
It exempt two things.
Correct.
One is it says that it is only for the purpose of
Agriculture or for the
agriculture, and the second for domestic purposes.
If I am doing it in own land.
Now, so far as it talks about the mining leased area. So it's not your own land. It's a leased land or demised land as we call it when a lease is given. So if you do something in your...
This is also a leased land.
True, that is what I'm saying. That if it is a leased land,
Yes.
then in that event, any excavation in 1990 may attract. But here it says I think the word is
Removal.
Removal from the.
removal. The word is removal.
Removed from the leased area. 25.
Yes, I know. I've seen that.
They said no person shall undertake any prospecting operation or mining operation or quarrying operation for minor mineral in any area except in accordance with the terms and conditions of a prospecting license, come mining lease, or a mining lease, or a quarry lease, or a quarry permit, as the case may be, granted under these rules.
So there is an absolute prohibition. There is an absolute prohibition of a mining operation or a quarrying operation. Neither the mining operation is defined, nor the quarry operation is defined in the rules or the act, nor even a minor minerals is defined in the act. So it simply talks about that if you do it without any permit, without any license, without any lease, then there is a complete prohibition. You can't do it. The only exception which is carved out is for agricultural purpose. Here also, the first proviso has to be seen in that line. It talks about the extraction. Provided that the extraction, collection, and a removal by a person from his own land.
Right. Own land for normal agricultural operation or other bona fide domestic consumption. Own land, there is a word is very important. Consumption shall not be construed as mining or quarrying operation. Here quarrying operation has been defined, but
yes.
V, looks at 2V, means any operation undertaken for the purpose of winning any minor mineral, other than specified minor mineral, shall include erection of machinery, laying of tram work, construction of road, other preliminary operation for purpose of quarrying.
So this quarrying operation is that you can use it for the purpose of any machinery. Here is a pond which is constructed.
As pond is being done.
Correct.
The quarrying area, in fact.
So actually, it is really.
And it is being used as the dike. The earth that has been extracted is being utilized for dike. Dike means the reach of the ash pond, not to the water shall not spill over. And they create a bund, like in a pond, in a bund in a pond. So that's called dike method. So for construction, they themselves admit we are using it.
That's on the embankment.
Yes,
That's an embankment
of the ash pond. So it is used for commercial purpose. That is the reason why, that's the government standard. That is the reason why government says it comes in the purview of mining, winning of minor mineral, and therefore you are liable on section 3(1), and charging section is section 3.
Then what would happen when the buildings are constructed? There are many cases where the leases have been given for a long term, on a long-term basis. And then the construction is done. In order to have a foundation or do such foundations, there is a digging. And the digging goes, considering the number of the stories one has to construct, the more the number of the stories, more deep you have to go to make a foundation. And then you'll have to excavate the earth. If you excavate the earth and later on fill it up after making certain construction, then it will attract the minor minerals.
Commercial purpose, it will attract.
I'm telling you. Then again, a dichotomy one can see. If it is used for embankment purpose, it is not for commercial purposes.
For embankment is commercial purpose.
What?
Because they want to construct the bund, otherwise they have
What is the purpose? If anything done
in further
in whatever in protection is a commercial purposes.
That is for commercial purpose. That is exactly.
What is the meaning of the word commercial purposes in a common parlance?
Commercial purpose means it is anything that is to be done in furtherance to the same work if something is utilized, which is ultimately to be used for commercial purpose. And they themselves admit, sir, actually what has happened, they admit, yes, we are liable, but 2016 rule is not applicable to us. That is their case. They
No,
say,
it was
they say 2004 rule is applicable. 2004 rule was something different, but language is different. This challenging section are not
no,
there.
no. What is the date of the incident?
The date of incident after coming into force of the act, the rule.
2004
Yes, 4 days after.
or 16?
16. When the tender was floated,
Yes, it was prior. When the work order was, or letter of intent was issued, it was prior or after?
After.
And the work commenced after?
After.
Okay.
That is, Milord, for us.
So that is their case.
No. This is for B, Milord, whether it will fall within the definition of change in law. Because if it is change in law, then this liable, if it is not change in law.
Contract.
That is not for the
There is a
state to decide.
specific provision in the contract. Change of law is applicable law. That is the law which is applicable at the relevant time.
Shiraji, this is something for us to decide whether you are payable or this is payable by you or me. But so far, Milord, the state is concerned. There is no difference in 2004 and in 2016. We are contesting with the state, Milord, that whether it is liable or not.
Whatever he has an agony and pain because he has been out of pocket a large number of them.
Refunded.
You have not given.
Refunded, Milord.
What refunded?
Refunded. Deducted from my running account because he should not have any pains, Milord. He should be, a spectator seeing me performing before you. I don't know why.
So you deducted from his running account.
We have not deducted withheld because the matter is.
But utilizing the money, withheld money. Yes.
My learned senior.
No.
Senior complete and let him go.
No, he has completed.
Not completed. He has to place.
Not to the detriment of anybody.
My learned senior has to place the agreement which he has entered with the petitioner. And whether
Question, I am telling you, what he has argued is, it is not the invocation of any contractual terms and conditions. It is not a case of a violation of the terms and conditions of the contract. It is not a case of a respective reciprocal obligations flowing from a contract. The question is leviability of a royalty on a particular act or a things which has been done. So that comes within the framework of the statutory provisions. Now the Supreme Court has also kept it open and said, let this point be decided by the High Court. Whether he has a contractual right to reimburse, he has a contractual right to deduct, that is between them. You are not a party to a contract.
Leviability of the royalty, if it is a part of the contract, can the petitioner.
Very interesting question. Mr. Das, then you are inviting a very interesting question. Can a state collect any fees or a tax on the basis of a contract? Still.
That is on the basis of the rules.
Statutory rules. Once all these things can only be done by virtue of a statutory provisions, then one has to interpret and understand that what this provision says or mean. Contract, forget what they have. The contract says many things, that any future impositions, the future levy, everything, liability, the contracting parties have shared. That is between them. But the question is whether you can levy the royalty for excavation of an ordinary earth, which comes under the entry 33 of 2016 rules. There is no difficulty. In Schedule 2, I have seen that. Whether you can charge when it is only for the purpose of making a pond and the entire thing is used there for an embarkment which cannot come under the purview of a removal. He says that the word is that you have used that particular word in Rule 35 is a removal. If the entire earth has not been removed, nor it is sold in the market, nor any charges or selling charges or something is charged on them, but it is again reverted back to the earth as an ordinary earth, does it attract the royalty, leviability? That's the point.
Yes. Now, so far as removal is concerned, before that, to my lord's notice that the land has been leased out to OPGC. And
For what purposes?
For industrial purposes.
Correct. Not for mining purposes.
With surface rights. Your lordship may kindly appreciate. With surface rights.
Always.
With surface rights.
Even an owner of the property has a surface right.
So far as the rights with respect to the minerals below the earth is concerned, that is absolutely, well, it is states.
It's a natural resources. It is a state asset.
Yes.
There cannot be any. That's why I'm saying, I'm asking. Suppose if construction of a building comes, it requires a deep digging. I think more than the ash pond. Deep digging, which goes even up to say around 100 feet or so, or a 50 feet, when a high-rise building is coming. I'm asking, will it attract the royalty when the earth, after making a foundation, is again filled? It can't. Will invite a very chaotic and I would say it will open a Pandora box for all in a sundry. Even Mr. Mishra will not dare to construct any house, nor you. That's the judgment has come where the buildings are being constructed and the royalty was imposed. Then say you can't charge. If it is for any other purposes, say for railway bridge or something like that, then in that event you can, because they borrowed those expressions from the 1990 rules, which includes those railway bridges and all everything therein. But 2016 rules, let us proceed on that basis, silent.
Let me go through that judgment my learned friend has referred to. Let me go through that judgment that is probably not of the Honorable Apex Court because I have.
No. There are division bench judgment of the other courts which have a persuasive value, may not be binding on us.
Those judgments, I'll request my learned friend to.
This is the take a judge.
Let me.
This judgment.
Please of those judgments, let me go through and come back the next week.
What?
You had given me copy. I'll give you copy.
In anticipation that you will agree.
They will have to agree with me, my lord. In fact, I will.
Is not. Is not.
If my money is protected, my lord, I'll agree.
Your money is protected. I am there to protect.
Let me just go through these judgments. I'll come back next week. Address on the point. So far as the rules governing, so far as those states are concerned, so whether those rules and the rules presently.
My brother, at least this is a greater advantage. Is more sound on the facts and the pleadings and the annexures. Definitely on law as well. Invited the attention from a particular notification which you rely in your counter at page 130, where the government notification, the central government has specified that what will come under the purview of a mining activities in relation to a ordinary earth, where it includes railway bridge and all, everything has been included specifically. So that is why it appears that those line of judgment of the Supreme Court which says that it attracts annuity is actually applicable in relation to those provisions. Now, once you consciously omit it and did not issue any notification of such nature, then what would be the impact?
But this notification says, it says in construction of embankment.
Yes.
Roads.
It is not an embankment. It's the roads, railways, buildings to
Construction
be.
of embankments, road, railway, building to be a minor mineral in addition to that.
Yes.
Ordinary earth.
Embankment is something different.
Embankment. It is not an embankment.
Ordinary earth used for
Embankment is different than embankment. Embankments is different than embankments.
I am reminded of a case argued by Mr. Ranjit Mahanti, I think, that is reflected in one of the sales tax matters. It is Orissa case, Guni Sahu, which is the putting earth from one place and filling up the bridge.
Right.
So that activity is not coming within the fold of sale at that time, when deemed sale was not there. So it is service activity.
Yes.
Transfer of property and goods is not there. So that way, 1950s.
So far as the word removal is concerned, it has to be read in the context of the definition for dispatch.
No, I
prescribed
understand.
under the
No,
Act
no,
double
no,
A
sir.
by-
There-
So Lordship may-
That is what is there.
21.
Is
That is 21.
But Hindustan Zinc has already, well, the Supreme Court has already defined what is removal. Hindustan Zinc and Tata Steel. They say, from the contents of what has been stated by the court, it's very clear that once a portion of the metal is returned back to the mother earth, it cannot be said to have been extracted or cannot be said to have been taken out of the leased area. And when the metal which was not been taken out from the leased area or which is not contained in produced, it cannot be made subject to payment of royalty. Because the leaseholder never took out the portion of the metal from the earth, and therefore that cannot be said to be the part of the metal controllable. This is Hindustan Zinc and Tata Steel also. If you are taking it out and dumping it there.
Definition of dispatch says means the removal of mineral or mineral products from the leased area and includes the consumption of the mineral and mineral product within such leased area.
that is in case of a captive mining of the things. Now the question is again, I'm saying, had it been a case of an other than atomic that concession rules, the position which is now under consideration, you can't bring it here in the concession rules, minor mineral rules, is different than the other than the atomic which is there. Rule 12 capital A is under challenge.
Yes.
Is a different one.
Tomorrow you will not see that.
That's a different one. You are trying to bring that dispatch definition, trying to bring that particular production. We have to now consider in the perspective of this particular rules.
So that is only the
Uh-huh.
2021.
That is. So in that, we have to consider in the light of that.
So I'll come back next week and explain.
But this
Go through
embankment,
all these judgments.
the
My
word
friend has seen.
embankment also refers to the dike.
No, that was in relation to a river.
Not only river, sir, it's also to hold back water. Not only river, it holds back to water also. So I was just looking at the definition. It said to hold back water, to confine the water, not confined to specifically refer to a river.
Then the earthen pitcher will also come, Mr. Mishra. Earthen pitcher is from a clay, or I mean ordinary earth, to hold water.
We have to look at the context of the matter.
They are asking for a time to ponder upon and introspect. When?
Next week, next Wednesday.
Yes, next Wednesday.
Now 11.
No, gone.
My request, would be possible not to put it high in the list. Patch up the evening flight, you will go back otherwise.
Put it as a concluding matter.
Deeply obliged.
This the announcement of additional charges. Without issuing any supervision.
If the rule permits, then what is the additional charges for mining activities?
It was 20 weeks total query, having a lease for 5 years over my private land. And that is for 2023. Kind of very fixing, executing the lease deed. They have fixed all the royalty with additional charges. And pursuant to that, I also paid. And all of the certain without any social notice. That you have to pay additional charges on the basis that earlier it was 130, that was added with 7, that was extended to 206. As per one instruction by the government, which is on the basis of Rule 39. And Rule 39 is pertaining to government organization, which is not at all applicable to me. That is my full submission.
Where is the state?
They have already filed counter number.
What is their stand?
And their stand is that as per the Rule 39, they have calculated the additional charges for high sand soil. I don't know from where they collected this concept, because this is unheard in the rules, maybe.
I also could not get it.
They issued one instruction and give it lies to the counter for a moment. Counter.
At page 10.
Yes.
India counter.
Yes.
2019 later.
Yes.
Yes, that is fixation of additional charge on unit quantity of minor minerals in case of quarry lease granted to government organization and for quarry permits under the provisions of OMMC rules. In inviting a reference to the subject cited above, I am directed to say that Rule 39 of OMMC rules provides the reservation of area for lease for quarrying operation by government organization, subject to such terms and conditions as may be decided by government. Sub-rule 5 of the said rule states that receipt to whom a lease has been granted under this rule shall pay to the government all amounts payable by a receipt under the rules and such additional charges as may be decided by the government from time to time. Keeping the above in view, government after careful consideration have been pleased to decide that average of highest additional charge dates received during last 3 to 5 years for leasing of the same mineral sources in the same council or nearby council or nearby district will be taken as the additional charge for lease of minor mineral sources in favor of government organization on nomination basis and also for issuance of temporary quarry policies. Well, this is the instruction, and on the basis of this instruction, they have issued demand that you have to pay additional charges, which is not at all applicable to my case because this is for only government organization. The rule.
And they have invoked this provision against you.
Yes, sir.
Where do I get it?
Officer.
Of
Petition, page 47.
47.
Yes, sir. Counter page number.
Yes. Yes, RDM department letter of 14/10/2019.
Average highest five.
No, I understand. That's the only point.
Yes, sir.
What do you say?
I have a preliminary objection, Malaks. Under Rule 46, there is an alternate application remedy available, and there was no challenge.
The very apt answer to this is once you have filed your counter, once the entire case is otherwise ready and matured for final disposal, can you take a plea of alternative remedy?
The ground has taken, and my
At the time of an admission, if you have not taken, can you take it subsequently?
question of law can be raised at any stage.
It's not a question of law, it's a question of discretion. Alternative remedy is not an absolute bar where you can raise a question of an absolute bar.
But
Is a question of the discretion of the writ court whether to accept or not to accept.
Yes, my lord.
So,
Even if to that extent.
but at this stage, can you take?
Yes, my lord, because
Show me one judgment.
only one.
I think I know 2 or 3 judgment against that. Once it has matured, affidavits are complete, then the plea of alternative remedy should not be resorted.
Here we have specifically taken a ground of alternate remedy at para 5, my lord.
At the time of admission,
Well, it's at the time of admission, there was nothing because
But
on the
that is
first day.
not the only ground which you
Of course,
have,
my lord, on
you
merit.
have answered
Yes, my lord,
on each
on merits.
paragraph and on merits.
Yes, my lord, on merits also.
Okay.
Well, first, I wanted to place my argument regarding maintainability because there is
there is a provision for an appeal. Let us forget.
And as per relying upon a judgment of Honorable Supreme Court, where
Correct.
statutory remedy is provided for, discretion under 226 should ordinarily not be entertained. my
Correct.
lords. That is my preference.
There's a 2-judge bench.
Yes, my lords. The recent judgment of Justice, Honorable Justice Chandrachud of 2021, my lords, which talks about, lays down all the Even my lords, Whirlpool also talks about the same.
Whirlpool is a different concept. I think even a Mohammed Nuh prior there too.
My lords, preliminary objection, and on merits, my lords, here after OMMC rules came in the year 2016, and these
Are you
agreements-
banking upon this particular letter of 14/10/20?
To that effect, my lords, that is my second answer. First, my lords, it is important to state the facts, my lords. Here,
I am asking, when a demand notice is raised referring a particular letter or a decision, then can you go beyond that particular thing?
Yes,
Again, I have to remind you of that judgment of MS Gill.
Yes, my lords. My humble submission is the reliance on 14th October is only to the effect of calculation. The calculation.
Can you do it?
Calculation is.
Can you do it? Because the modalities are given. Show me where is your authority to charge an additional.
Rule 32, my lords.
That is, he has already paid at the time of the query permit. Can you charge more than that?
Yes, my lords. That is also provided in the.
Where is the provision?
That one line, my lords. Here the option, there were no option, and the lease is.
He is owner of the property, is a surface right he has, which is a constitutional right. He found that there is a whatever the minerals beneath it. Then it is the asset of the government. They have to approach the government for giving me a right to query. That is what your case is.
It's here after the 2016.
They have imposed all the rent, royalty, additional charges, everything have paid. Now all of this are doing.
It's here after 2016.
Further additional charges can you? That is the case.
I'll show from the lease deed also and from the provisions of the, if I can satisfy my lords. The only thing is that after 2016 came into the picture, no lease agreement could be executed without an auction, my lords. Here, admittedly, there was no auction and there was loss of revenue because of which these steps were taken, my lords.
I understand. Then can you do a particular thing which is not provided in the statute?
Yes, my lords. If I may refer to rule.
You could have immediately terminate the contract.
Yes, ma'am.
You could have said suspend. I am not going to allow you. Can you still, that means tacitly you are permitting him to continue with the query and pay me something more. Are you not doing such a patent illegality? I'm asking.
Well, if I may
You are talking about 2016 rules saying that it cannot be done without auction rules being followed. The auction regime came in 2015. The conventional or the old method of giving through an executive fiat is done away with. I appreciate. Cancel it. You should have immediately, when it comes to your notice, you should have immediately cancelled it. You chose not to cancel. Permit him to continue. And then you say, pay me back. All these illegalities which you have done becomes legal by payment. Is this a law? You can charge anything provided it is the statutory provisions permits you to do so. Additional charges you can levy. There is a provision. But he has already paid the additional charge. This is a further additional charges. And that too the modalities you have adopted, which is applicable only to a government organization, not to a private individual.
That notification of 2019 is under 39 Rule 5, which applies to government organizations.
So,
well, it's the
can you apply to an individual?
Calculation aspect was only considered because there was.
Madam, I will accept it. It's a very, very interesting and innovative argument that even if the document as a whole is not applicable, for a limited purpose, I can extract the portion thereof and apply.
Page number.
Very interesting.
Page number 12 of my counter affidavit, my lords.
I've seen that. That's why I'm saying.
It's page number 12, my lords. That is actually the upon which these demands were given, my lords.
What is the actual, on which demand is raised? You just tell me.
Page number 12, if I may read, my lords.
Please.
In inviting a reference to the subject cited above, I am to say that on the report of Sub-Collector Jharsuguda regarding settlement of 11 numbers of minor mineral sources beyond the scope of OMMC Rules 2016, Collector Jharsuguda has been pleased to order for fixation of additional charges on the rate of royalty.
Under what authority? Under what provision? No, I understand. And then it is done. Under what authority? Yes.
royalty assessed during the time of settlement of these sources under Lakhanpur Tehsil. Additional charges may be calculated as per the instruction of 2019. The basis of calculation was 2019 minus. And Rule 32 talks about additional.
Judgment of any court that a particular document as a whole is not applicable in a particular situation, but for to what it suits, one can extract therefrom and apply in a different situation. I will be enlightening myself on this.
Page number.
I do not know.
Page number 46 of the writ petition, which is the lease document. Minutes. Here it mentions that the lessee shall pay royalty in advance and the differential amount.
So the law is very subtle, very preliminary, foundational. First principles of law is an individual can do anything unless forbidden by law. But a government organization cannot do anything unless provided by law.
Yes, ma'am. To that reference, only.
That's the two fundamental basic principles one should embrace.
Only Rule 32 is there where this charging provision.
Yeah, there is only for additional charges which he has already paid. It is a further additional charges that to the mechanism of calculation or method of calculation you have borrowed from a document which is not applicable to an individual, it is applicable to a government organization. How can you do it?
Yes.
Can't do it. No, it has to be quiet. You can't borrow it, something.
Also, there were irregularities in the sense there was the
Impose a penalty, madam. I said that once you found that this lease is in contravention, terminate. Where is the difficulty? But you are regularizing the illegality by imposing a further additional charges. Can you do so? I will be writing these words in the order.
One more aspect, with respect to royalty, but
The royalty that is there, that he has to.
Also, with respect to DMF, DMF was charged 5%. Actually, as per rule, it should be 10%. That was also asked for in the impugn demands. And actually, one which is under challenge.
If it is 10% he will pay.
That is
No difficulty. The royalty is paid in accordance with the rate which is given in schedule or to the rules. If the schedule to the rules says that it is a 10%, you have to pay. If it is 5%, you have to pay. That's all. So that's all. If it is 130, then it is 130. They cannot charge something beyond it.
As per the rules, my lord, they have to bring amendment.
I understand.
And the judgments, my lord, where your lordship has dealt with that one rule, application of one rule that cannot be applied to other set of persons, my lord. My lord, at 5.2 of Sasan Yadav. And my lord, another two judgments where additional charges which has been given at the end, later end, that has been caused by your lordship in Sandeep case, which has to be raised at the fortnight of every year, my lord. They are raising it after passing of 3 years.
Oh, luckily this is not.
And this has been caused.
With respect to DMF and EMF, at least it should be as per the rules, my lords.
Look at your dilemma. Every point you are raising, they are coming up with the judgment that this bench has already decided. Look at your.
See that judgment.
Nothing.
My lords, only page 18, my lords, which deals with Rule 9.2 of ODMF, which prescribes that 30% of royalty if the lease has not been granted through auction, my lords. This case falls under that, my lords. So 30% of the royalty has to pay for DMF. That has not been paid. That is part of the demand. Second,
Did you charge a 30%?
Yes, my lords. Page number 18, my lords.
Or
Reading out as a whole, where they can ask for additional charges if there is an illegal extraction or there is a shortfall. My lord, they can ask, and to that effect, every fortnight of the
Just
year.
go to the facts and just tell us, we'll see.
Item